Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare recess at any time. Pursuant to notice, I now call up H.R. 2152 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2152, to require states and units of local government receiving funds under grant programs operated by the Department of Justice, which use funds for pretrial services programs, to submit to the Attorney General a report relating to such program and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Today we consider H.R. 2152, the Citizens' Right to Know Act of 2017, offered by the gentleman from Texas, Mr. Poe. A little over 50 years ago, there were 3 pretrial options for defendants accused of a crime. They were either released on their own recognizance, commercial bail, or remanded to custody. When considering the options on whether to grant ROR, release on one's own recognizance, set a bail amount, or remand, the judge considers a number of factors, including the severity of the crime charged, the suspect's criminal record, the danger posed to the public if the suspect is released, and the suspect's ties to family, community, and employment. Commercial bail ensures the appearance of the defendant in court at no cost to the taxpayer. The situation for defendants began to change in the 1960s. The first U.S. pretrial services program, the Manhattan Bail Project, was established in 1961. The Manhattan Bail Project was intended to help defendants who were financially unable to post the surety bond conditions set in New York City. The program interviewed defendants to gather information on community ties to determine a defendant's likelihood of appearing in court. Based on these interviews, low-risk individuals were recommended for release on their own recognizance, or the defendants promised to appear without financial obligation. Unfortunately, over the last 4 decades, pretrial release programs have expanded well beyond their original scope and purpose. Today, there are over 300 pretrial release programs nationwide whose participants routinely include violent and repeat offenders, many of whom are able to post a commercial bond and have done so in the past. In many instances, the federal government has become a major source of funding for pretrial release programs. When the Bureau of Justice Statistics examined the pretrial release phase of the criminal justice process using data collected from a representative sample of felony cases filed in the 75 largest U.S. counties, they found that compared to release on recognizance, defendants on financial release were more likely to make all scheduled court appearances. Defendants released on an unsecured bond or as part of an emergency release were most likely to have a bench warrant issued because they failed to appear in court. H.R. 2152 says if a jurisdiction receives grant money from the Department of Justice to operate a pretrial release program with federal dollars, that jurisdiction needs to report to the Attorney General certain information concerning the defendants. The bill requires the jurisdiction to submit the criminal histories of the defendants and the number of times the defendant has failed to appear as ordered by the court. It also requires the Attorney General to make public the information the Department of Justice receives. In my mind, that isn't a whole lot to ask of these jurisdictions. In fact, this bill is beneficial because citizens have the right to know what types of defendants are being released prior to their trial. If defendants have a long history of criminal behavior or frequent failure to appear in court, the community should know that. Likewise, residents should be aware if their community is running a successful pretrial services program. Simply put, no matter what side of the bail or no bail debate you find yourself on, you should support this bill. Information like this in the hands of the public is never a bad thing. It will also be helpful to those of us who make policy on these matters. I want to thank Mr. Poe for introducing this legislation, and I'll be offering an amendment in the nature of a substitute that I urge my colleagues to support. It's now my pleasure to recognize the ranking member of the committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman and colleagues, before I discuss the bill before us, I want to say a word about what is not before us, namely legislation to strengthen our firearm laws. This is the committee's first markup session since the tragedy at Marjorie Stoneman Douglas High School on February 14th. I want to recognize our colleague Ted Deutsch, who represents Parkland, Florida, and who has worked tirelessly to help the grieving families and who has been a fierce advocate for sensible gun safety legislation. As the Democratic members of the committee stated in our letter to the chairman on February 21st, it is long past due that the committee with jurisdiction over our gun laws take action to reduce the level of gun violence that is not only a periodic but still too frequent mass shooting issue and one that impacts communities across our country every day. At the end of last year, this committee reported the bipartisan fixed NICS bill, which would help get more information from state and federal agencies into the background check system. Of course, even the modest fixed NICS bill only made it so far in this House as an independent bill. Unfortunately, the House did not take it up separately, but instead included it in a very dangerous bill to expand the concealed carrying of firearms in this country. The fixed NICS bill is as good as far as its limited scope will allow, but if we recognize that plugging gaps in the system is a worthy goal, then we should also proceed to plug the biggest gap in the system. The fact that no matter how complete the information in the system, the background check requirement does not apply to guns sold by those who are not licensed dealers. That is what we should address without delay. Even President Trump, in his meeting with members of the House and Senate, recently urged action on expanding background checks. We should do this and more, including addressing the issues of assault weapons, high-capacity ammunition magazines, and gun violence protection orders. We know what to do. We just need to summon up the will to do it, and I hope that we will do so. Any legislation to address these issues must be processed promptly, but through regular order by this committee. Relatedly, I note that we have been told that H.R. 4909, the Stop School Violence Act, will be considered on the floor under suspension of the rules next week. Although that is a bipartisan bill concerning school safety, I believe the committee should have marked it up so that our members would have had an opportunity to discuss it through our regular process. I hope we will follow that process in the future. Now, Mr. Chairman, I believe the consideration of the issues underlying the bill before us is timely, but unfortunately misguided. This committee should examine pretrial services and bail issues with the goal of reforming our nation's bail system, not solely for the purpose of protecting the use of money bail, which is unfair to the indigent, unproductive, and expensive for American taxpayers. H.R. 2152, the Citizens' Right to Know Act, would require a state or local government that uses Justice Department grant funding to pay for a pretrial services program to report annually certain information to the department about defendants who participate in the pretrial services program. Information that would be required to be reported includes 1, the name of each participant in the pretrial services program and each occasion that person failed to make an appearance, 2, the previous arrest record of each participant, and 3, the amount of money allocated for the pretrial services program. If the unit of government fails to comply with the reporting requirement, it would lose its entire funding under the relevant program for the following fiscal year. The requirements in this bill largely mirror legislative initiatives being advanced by the ALEC, the American Legislative Exchange Council, in the states under the guise of transparency. Now, citizens do have the right to know what the government is doing, and I support the reporting of information that will educate us as to what is taking place. As for H.R. 2152, however, I question whether the categories of information that must be reported under the bill are designed to do that or are adequate to tell us about the efficacy of these programs. In addition, the bill requires that this information be made publicly available by the Attorney General. The ACLU has written to us to express concerns about this publication requirement and the harms to individuals resulting from the sharing of their arrest records and personally identifying information. I share these concerns. I will discuss these issues more fully in connection with the substitute amendment, which will be offered shortly. However, my principal concern is that we are marking up the wrong bill. Our colleague, Representative Ted Lieu, who could not attend the markup today, introduced not 1 but 2 measures that would help eliminate the use of money bail in the states. H.R. 1437, the No Money Bail Act, would reduce Justice Department grant awards to states that do not eliminate money bail. H.R. 4019, the Pretrial Integrity and Safety Act, takes a slightly different approach by providing grant funding assistance to states that eliminate money bail in favor of systems that evaluate defendants to place appropriate conditions on their release and follow up with monitoring. Instead of considering H.R. 2152 today, we should be advancing one of these bills. We are not doing that, unfortunately. Therefore, in connection with the substitute amendment, my colleagues and I will discuss our specific concerns with this bill. I hope that we will be able to address some of these issues. If we do, we can support the bill. If we do not, I will oppose the bill. Whatever the outcome today, I hope this discussion will highlight the need to do something about the real problem, our nation's unjust money bail system. Thank you. I yield back.
Chair thanks the gentleman. I now recognize myself for the purpose of offering an amendment in the nature of a substitute, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2152 offered by Mr. Goodlatte. Strike all that follows after the enacting clause and insert the following. Section 1, short title.
Without objection, the amendment will be considered as read, and I recognize myself to explain the amendment. This amendment in the nature of a substitute makes one substantive change to the legislation. The amendment adds one additional piece of information required by the state or unit of local government that is to be submitted to the Attorney General. It requires them to report the amount of money allocated for the pretrial services program. The underlying bill requires these entities to report on the number of occasions that the defendants failed to make an appearance, as well as the defendant's criminal history. This new section will allow citizens to see if their tax dollars are being judiciously used to fund pretrial services. It provides another level of transparency to these programs. It also helps us as legislators to have this information as we make decisions in this area of criminal justice policy. I urge my colleagues to support this amendment, and I'm pleased to recognize the gentleman from New York for his remarks on the amendment.
Thank you, Mr. Chairman. Mr. Chairman, my comments concerning the underlying bill apply equally to this substitute amendment, which I believe is a lost opportunity to actually do something that will make our systems of pretrial release more just, and that is to eliminate money bail. With respect to the specifics of the bill, I have a concern about the information that the bill requires to be reported, particularly the name of each participant and of the pretrial services program and each occasion that the named person failed to make an appearance. The reporting of this information without proper context, in addition to being unfair to those whose information will be made public, will not be useful to those of us seeking to understand how these programs are operating and the relative merits of different approaches. As outlined by the Pretrial Justice Institute, the three goals of the pretrial release decision are: 1, to maximize pretrial release; 2, to maximize public safety; and 3, to maximize court appearances. The information required to be reported by this bill would only address the third factor with respect to court appearances. I am concerned that the information to be reported does not tell us anything about the first two factors, maximizing pretrial release and public safety. I understand that an amendment will be offered by one of our colleagues to address this concern. In addition, I reiterate my primary concern with respect to this bill, which is that it does not accomplish any degree of reform of bail in this country. Therefore, I will offer an amendment to provide incentives for the states to eliminate money bail. I look forward to our discussion of the substitute and amendments that I and other members will offer. I thank you and yield back.
Are there any amendments to the amendment in the nature of substitute? For purpose, the gentleman from Tennessee seek recognition.
Strike the last word.
I was recognized for 5 minutes.
Would the chair yield for a question? This amendment of yours, will it require appropriations to fund the data and the study of pretrial services?
I don't believe it would.
But they would have to, there would be a study, right?
It requires the states that have pretrial services programs to report. It would not require the federal government to expend.
But they would report to whom?
To the Department of Justice.
And the Department of Justice then would do a study?
I don't think it calls for a study.
Just to report?
Correct.
Well, if that's all they're going to do is report and nobody's going to study it, then it's a total waste of time and money, because the only reason to report is to make a study and to analyze those figures. And that takes people away from what they'd otherwise be doing. In my experience as an attorney in Memphis, which was about 30 years in private practice, pretrial services was looked at the good guys. There were people that recommended to the judge, and the judge relied on them for reports on individuals on whether there should be a low bond or no bond, and sometimes they could get people out without any bond on their own recognizance on that recommendation. The study of pretrial services is kind of interesting. We want them to send up data and analyze it, but we don't want to study anything about guns. We don't study guns. In fact, we've got a law that says the CDC can't do a study on violence and guns and what that does to our society. We just had 17 people killed in Parkland, Florida. And have we done anything about guns? Nada. Nothing. It's going the same way as bump stocks. Nothing. And this country, it's not just children, which is horrendous. It's people going to concerts in Las Vegas. It's people at government offices in San Bernardino with adults using AK-47s. And if we asked anybody to send us data on people that buy guns and who they are, have we tried to study that? Have we looked at minors and purchasing semi-automatic weapons or high-capacity magazines? Nothing. But we're going to have a study of pretrial services. I would submit to the committee members, we are fiddling while Rome burns. Our children are dying, our citizens are dying, our public is less safe, our country is in crisis. While we do have Mr. Cohn resigns, people are leaving the administration. It is not a place where people want to go to work. People are smart. They don't get on the Titanic. They've seen the movie. It's being acted out at 1600 Pennsylvania Avenue live. And we're looking at studying pretrial services? Something's missing, Mr. Chairman, and I'd like to ask you once again to do something in this committee on preserving democracy, studying elections, seeing that our elections will be safe and free of Russian interference in 2018 and 2020 and thereafter, looking into guns and protecting our children, and not necessarily making local governments make reports on pretrial services that will sit in the dust bin at Justice Department and gather dust for no purpose. I yield back.
Are there any amendments to the amendment in the nature of substitute? For purpose, gentleman from Georgia, seek recognition. Do you have an amendment?
Move to strike the last word.
Let me recognize the gentleman from New York, since he does indeed have an amendment. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2152 offered by Mr. Nadler. Add at the end the following.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you. Mr. Chairman, before my statement on the amendment, since it is based on a bill by Mr. Liu, who could not be here, I ask unanimous consent to insert into the record the statement by Mr. Liu.
Without objection, be made a part of
Chairman, I
it.
reserve a point of order.
On the statement?
I reserve a point of order. On the amendment.
Oh,
Okay, a point of order is reserved.
very good. Thank you, Mr. Chairman. As I've mentioned previously today, I believe we should eliminate the use of money bail in this country. That is why I offer this amendment to incentivize states to eliminate money bail. Under the amendment, states that have not eliminated the payment of money as a condition of pretrial release in criminal cases within 3 years of enactment of this bill will not be eligible to receive burn justice assistance grants from the Justice Department. This amendment is based on the No Money Bail Act introduced by our colleague, Representative Ted Lieu, who is not able to attend the markup today. He and I share the view that the continuation of money bail is an injustice that is national in scope and which demands a national solution. The money bail system does not address criminality, but rather penalizes poverty and the inability to pay. It is unfair and expensive. 9 out of 10 people awaiting their trial in jail are there because they could not afford to pay bail. This costs taxpayers billions of dollars every year in incarceration costs because we have to pay for these individuals to be needlessly detained. Incarcerating people because they cannot afford to pay their bail only perpetuates their financial difficulties by preventing them from going to work, buying groceries for their family, and paying for rent and other expenses. Some of the people who are held in pretrial detention are set up to fail. Studies show that people who are detained during pretrial have worse trial outcomes than people who are able to afford their freedom while awaiting trial. This is partly because many people plead guilty to the charges simply so that they can be released rather than face a lengthy pretrial detention. Defendants with more resources purchase their release, while defendants with limited or no financial resources remain in jail regardless of whether they are a danger to their communities or whether they are unlikely or likely to show up in court for their hearings. In fact, the ability to pay money bail is not an indicator of a danger that one may pose to others. Research has found that in many of the largest U.S. jurisdictions, approximately half of people detained in jail would have been less likely to be rearrested than those who had been released. Pretrial services programs that promote alternative forms of pretrial release are less expensive and more effective. Right outside these walls, the District of Columbia has eliminated the use of money bail. As a result, 85% of defendants are released before trial, more than 90% of whom return to court and stay arrest-free while their cases are pending. This is compared to an average of only 40% of defendants being released before trial, of whom about 72% return to court under the money bail system. These facts supporting the need and benefits of eliminating money bail are the reasons I offer this amendment. And let me just stress again, there are two legitimate purposes for pretrial detention. One is to assure that someone will show up for his trial, and two is to protect the public from dangerous criminals being released. Those determinations can and should be made by the judge based on all the evidence and all the factors and all the information before the judge. The ability of the accused to pay money does not tell us that he is more or less likely to show up for trial, and it does not tell us that he is more or less likely to be a danger. It simply puts people in jail because they cannot afford bail. We know that there are many judges who will assign nominal bail, $250 to almost every case. It's minor, nothing. But for $250 may be unaffordable and keep someone in jail for a lengthy period of time at a great cost to the taxpayers and a great unfairness to the accused. So we ought to have a system in which the judge, based on all the evidence, determines the risk of flight, the risk of showing up, the likelihood of showing up in court, and the risk to the public, and makes pretrial detention-based decisions on that basis and not on the basis of jail. We used to, a century ago, we used to think nothing of holding people in jail because they couldn't pay their debts. Now we think that's a barbaric practice. This should go, the money bail system should go in the same direction. I offer this amendment, and I ask that my colleagues work with me to achieve this goal of greater justice, not to mention saving the taxpayers a lot of money. I yield back.
Does the gentleman insist on his point of order?
Mr. Chairman, yes, I insist on the point of order.
The gentleman will state his objection.
Mr. Chairman, the underlying substitute amendment creates a reporting requirement on pretrial services. The Nadler Amendment prohibits states from requiring defendants to post bail. While this amendment is close to the line on germaneness, I believe it crosses the line, and therefore I must insist on my point of order. Now yield back.
Does the gentleman from New York wish to be heard on the point of order?
Yes, I'll simply say that unfortunately the point of order is well taken, but the fact that this amendment is offered in the way it is on a bill that it is, and the point of order offered, I don't know, do you offer the point of order
You make it.
made, is an illustration of the problem that we face, and that we're dealing with a minor aspect of the bail system instead of dealing with the bail system as a whole, which we should do, and I hope this committee will do. I'll withdraw the amendment.
Gentleman withdraws the amendment. Are there other amendments to H.R. 2152 substitute? First,
I move to strike the last word.
The gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. This bill has an ominous name to it, the Citizens' Right to Know Act. It's ominous in that it implies that pretrial services offered by state and local governments must be something wrong with it, and so there must be some secret, something that is being withheld from the people, and this Citizens' Right to Know Act of 2017 would purport or implies that it's meant to, provide some kind of transparency and make things better. And nothing could be further from the truth. Pretrial services run in state and local court systems across the country. Why would the federal government decide it now wants to gum up their processes by having them report to the federal government these various categories of numbers, thus taking away from the work that they do? There's something wrong with this. This doesn't smell right. And I suspect what it is just an attempt by this committee to show that it's doing something, when in fact the committee is not taking care of the business that is pertinent to the citizens of America that should be overseen by this committee. This committee brings this legislation up for a markup today, when in fact there are many other issues that we need to address that have gone unaddressed. So this is kind of like putting clothing on a pig to make the pig look good, when in fact the pig is just a pig. This committee is not doing the work that the American people would benefit from if it was doing its job. Job number one, oversight of the excesses of the Trump administration. Not one hearing before this committee in the last year and 3 months on any excesses of the Trump administration. We've just had some obligatory appearances by the FBI and the DOJ. They come here every year to give their report, and that's the extent of our oversight. It's a poor record. I want to associate my remarks with those of Representative Steve Cohen, who was eloquent in his assessment of this bill and its imperfections. I mean, we're going to require the reporting of information, but then there's no follow-up once that information is received. So it's clear, that's clear and convincing evidence that this is just something to gum up the works of the state and local governments, while at the same time providing a cloak for inaction by this committee on issues of importance to the American people, such as how could an 18-year-old down in Florida accused of killing 17 of his fellow students, how could he walk in and purchase a weapon of war at the age of 18, hours after he gets his, becomes 18 years of age, walks in and purchases a weapon of war, an assault weapon? We've not had any hearings on that issue. And so I would just implore the committee to, we still have time before this year ends to salvage the reputation of this great committee and to do something that the American people would be proud of us for doing. And with that, I will yield back.
Purpose the gentleman from Rhode Island seek recognition.
I move to strike the last word, and I also have an amendment at the desk.
Oh, clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2152 offered by Mr. Cicilline of Rhode Island. Page 2, strike line 13, and all that follows through line 19.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. And before I speak to my amendment, I too would like to add my voice to my growing disappointment that this committee has been unwilling to take up any of the dozens of gun safety proposals that are pending before the Congress that attempt to prevent the most dangerous weapons, military-style assault weapons being placed in our communities, that attempt to keep guns out of the hands of criminals, young people, or those with serious mental illness such that having a firearm is a danger to themselves or others. I, like so many of my colleagues, have introduced and authored legislation designed to respond to the epidemic of gun violence in our country, and sadly, this committee has not had a hearing or taken up any of these bills, specifically legislation that would attempt to make it more difficult for people with serious mental illness to buy firearms. I introduced, along with 170 co-sponsors, a bill to prevent bump stocks from being available that turn a semi-automatic weapon into, to function as an automatic weapon. Last week, introduced the assault weapons ban with 170 original co-sponsors. And again, there are many, many other bills that would go a long way to reducing gun violence in our country. And sadly, even despite the eloquent voices and pleas from the young people from Parkland for us to do something, this committee still remains unwilling to do that, and I want to express my disappointment and again urge the committee chairman to bring some of these proposals to the committee for a debate and vote so that we can demonstrate to the American people that we're doing something to keep themselves safe and reduce gun violence in this country. Now, with respect to my amendment, the amendment that I have proposed would protect funding for state and local governments that seek to offer pretrial service programs. H.R. 2152 is short-sighted because it would jeopardize states' ability to offer pretrial services programs by threatening their funding. Congress should instead incentivize the use of pretrial service programs which benefit defendants, courts, and taxpayers. For example, unnecessary detention before trial results in burdensome costs to taxpayers who spend approximately $38 million per day to jail people who are awaiting trial. Pretrial service programs importantly reduce the number of defendants languishing in jail because they cannot pay money bail, even though they may not necessarily pose risks to the community or risk of not appearing in court. Pretrial service programs also benefit the courts by allowing judges to make more informed decisions that take into account the individual risks of each defendant and to tailor an appropriate sentence for their circumstances. This bill, as currently drafted, would entirely take away funding from states that fail to report required information regardless of the circumstance, even if the failure to comply was not intentional. This standard does not target willful failure to comply. It is arbitrary and overly punitive for states that are administering pretrial release programs in good faith. My amendment would only allow funding to be taken away from states that knowingly fail to comply with the reporting requirements under this bill. My amendment would also change the requirement that funding for states be reduced by 100% and instead reduce funding by a pro rata share of the placement cost of each defendant not reported. So it would be proportionate to the harm done or by the non-compliance that occurred. A state's funding should not be zeroed out if they are complying in part with the reporting requirement or fail to submit information in error. I'm concerned that if this section of the bill is not amended, it could undermine the effectiveness of many pretrial release programs. If pretrial service programs that receive federal funding know that their future funding will be determined by the number of names on a list of persons who missed a court appearance or a supervision appointment, they may be incentivized to supervise less people. In addition, if they know that they will not be judged by a reasonable metric such as public safety standard or maximizing court appearances, they may not focus their supervision efforts on these goals. My amendment will preserve funding for pretrial service programs which serve the important function of reducing the high incarceration rate and bringing down the cost to taxpayers while also maximizing public safety needs and due process of defendants. I urge my colleagues to support this amendment and yield back the balance of my time.
Chair thanks. Gentleman recognizes himself in opposition to the amendment. This is an unenforceable, and this information is unknowable. The federal government has no way of knowing if the locality is underreporting, and this amendment encourages the federal government to micromanage these programs, which is not the intent of this legislation. It is simply to get information about which of these programs is cost effective and which is not, based upon whether people show up at court following a pretrial release program. So I urge my colleagues to oppose the amendment. Question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. The amendment is not agreed to. Are there further amendments to?
Yes, Mr. Chairman.
Gentleman from Rhode Island is recognized.
Mr. Chairman, I have an amendment at the desk
The clerk will report the
that I'm offering on behalf of the gentlelady from Texas.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2152 offered by Mr. Cicilline. Page 1, strike
Without
line
objection,
17.
the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. H.R. 2152, according to its proponents, is intended to bring accountability to federally funded pretrial release programs by increasing oversight of such programs. However, this bill raises substantial privacy concerns with regard to the personal information that states and local governments would be required to report and fails to require data that would actually provide a report on the effectiveness of pretrial release programs and money bail. I have a letter that was sent from the ACLU today, which I would ask unanimous consent be made part of the record. Without objection.
Without objection.
Thank you, Mr. Chairman. Which voices strong opposition to this bill because it would require jurisdictions to report personally identifiable information without providing any explicit privacy protections other than the clause that subjects the information to any applicable confidentiality requirements. The jeopardy to the privacy interests of individuals who have not been convicted of the crime for which they are under pretrial supervision substantially outweighs the public's minimal interest in the required information. Furthermore, H.R. 2152 would require state and local governments to report the names of each defendant under pretrial supervision who fails to appear. This data, without more, fails to further the intended goal of H.R. 2152. My amendment would replace the reporting requirements in the existing bill with provisions that would actually help us fully understand pretrial release programs and money bail. Ms. Jackson-Lee amendments would require state and local governments to report the number and percentage of defendants who appear at an initial bail hearing and are released on their own recognizance, participate in a pretrial release program without having financial obligations imposed as a condition of their release, participate in a pretrial release program without being arrested for additional criminal activity, participate in pretrial release programs without having a bench warrant issued for their failure to appear, are released on money bail and complete the pretrial period without being arrested for additional criminal activity, and are released on money bail and complete the pretrial period without having a bench warrant issued for their failure to appear. This amendment would allow for a robust collection of data that would provide a clear picture of the efficacy of pretrial release programs and money bail instead of presenting a one-sided account of a single element of a more complex issue. I urge my colleagues to support the Jackson-Lee amendment, and with that, I yield back. Oh. You can.
The chair thanks the gentleman, recognizes himself in opposition to the amendment. This amendment mandates states report on all defendants. This amounts to an unfunded mandate, and it requires states to report on defendants with no nexus to the federal grants. It also strikes the information in the underlying bill. If states fail to comply with these requirements, they will be forfeiting their right to future grants. For those reasons, I can't support the amendment. If the gentleman wishes to introduce this as a separate bill, he can certainly do that, but it does not have a nexus with the federal grant programs, and therefore I must oppose it. First gentleman from Georgia, seek recognition.
Move to strike the last
Gentleman
word.
recognized for 5 minutes.
Thank you, Mr. Chairman. I move in support, or I speak in support of the Jackson-Lee amendment presented so ably by my colleague, Mr. Cicilline. And I would make this observation. The underlying legislation, Section 2, which is the reporting requirement, could have the unintended consequence of benefiting the private prison industrial complex. We all know that this private prison industry is growing by leaps and bounds. In fact, the stock went up just as soon as President Trump took office because he made certain promises to that industry, and that industry has continued to prosper since that time. This legislation, as I said, could have the unintended, perhaps, consequence of benefiting that industry because Section 2 requires that any state or local government that fails to report as required under Section 2 would lose 100% of its funding under the grants that it receives from DOJ. All of those, it would lose 100% the following year for failing to report. And so many of these states and local governments are turning to the private prison industrial complex. They're privatizing their jail systems and turning that over to the private prisons, which make a profit off of detaining folks for as long as possible. They operate with mandatory, guaranteed beds. They get paid whether or not the beds are filled or not. And so the incentive is to get the beds filled. And so I just want to make that observation about this legislation, and I would hope that it's not our intent to benefit that industry with this legislation, but it certainly could be benefited as a result of this legislation. And with that, I will yield back the balance of my time.
The gentleman From Maryland, seek recognition.
Move to strike the last word, Mr. Chairman.
Gentleman's recognized for 5 minutes.
Thank you very much. I'm rising in favor of the Jackson-Lee amendment because it would actually require the collection of data that would improve the effectiveness of pretrial release programs and money bail. Having said that, Mr. Chairman, I must confess my bewilderment and bafflement and alarm about where we are and why we're even dealing with this legislation today. Across the country, millions and millions of Americans are demanding action on gun violence after the most recent massacre that took place in Parkland, Florida, where 27 of our people were shot down by an AR-15 by a criminal who decided to assassinate high school students and their teachers. The most recent poll demonstrates, Mr. Chairman, that 97% of the American people want a universal criminal and mental background check on all gun purchases in America. And we know that's perfectly constitutional under the Second Amendment if you take the time to read the Heller versus District of Columbia decision. So we've got legislation that is being demanded by the overwhelming majority of the American people, almost a unanimous verdict by the American people, that we need a universal background check, and yet the Judiciary Committee, which has jurisdiction over guns in America, won't even have a hearing on it. And now we have a bill that comes before us about the funding of pretrial release programs and oversight of pretrial release programs without even a hearing, and we rush the legislation to a vote here without even a discussion about the gun violence that's engulfing America. How many more massacres do we have to wait for? How much more gun violence do we have to experience before we take action? So I'm stunned and bewildered about where we are right now. It's hard for me to believe that we're taking up this legislation we haven't even had a hearing on. None of my constituents have asked us to do anything about this, and yet thousands of my constituents have marched on the Capitol and are coming back on Saturday, March 24th. Hundreds of thousands of people are coming to march about gun violence, and what are we doing about it? We're doing nothing. So look, we've taken an oath of office to uphold the Constitution, which we're going to do. And we've taken an oath of office to listen to our constituents and to try to advance the general welfare. The whole purpose of government, as you know, Mr. Chairman, is to enforce the social contract. The whole basis of the social contract is that we'll be safer entering into government together than if we don't have it. Without government, life is nasty, brutish, and short. Solitary, poor, nasty, and brutish, and short is what Thomas Hobbes said. So we enter in government together to make ourselves safer. We are failing the most elemental obligation of government. We are not keeping our people safe. And we get a parade of these bills that are foisted upon us that nobody's asked for, that nobody really cares about, and nobody's paying attention to. And the people of the United States want to know, what are we doing to stop gun violence in America? What are we doing to enforce the social contract? What are we doing to keep kids safe in public schools? What are we doing to keep people safe in their churches? What are we doing to keep people safe in the movie theaters? Well, right now, the Judiciary Committee is doing nothing. I yield back, Mr.
Gentleman yield.
Yes, I would.
I would make the and I thank the gentleman for yielding. I'd also make the observation that this legislation comes before us today for a markup without a single hearing in a subcommittee or before the full committee. This legislation is rushed to us and put in front of us for action, and it's almost like it's busy work. I'm puzzled as to why we're doing business this way. And with that, I'll yield back.
Well, thank you. I appreciate that. I'm not saying that the issues contained in this legislation are unimportant, but certainly they're not more important than keeping the people of America safe, and certainly that's what the people of America want on the public agenda. So I don't understand how we're prioritizing the work of the American people. Now, a lot of pundits and commentators and a lot of Americans believe that the NRA is dictating our agenda. And that's hard for me to believe. So that's why I'm baffled and bewildered, because I can't believe that one special interest group could override the clear demands of the common good. I can't believe that one lobby would be able to essentially convince Congress to ignore a crisis in public safety in the country. So,
Would the gentleman yield?
yes, I would.
This bill hasn't had a hearing, is that correct?
As far as I know, I've not.
Have there been just bill after bill after bill that's gone to the floor, if not to the committee, with no hearing?
That's my understanding.
It seems like it's in keeping with the coming Passover. Why is this night different from all other nights? Why is this bill different from all other bills? It's not. It doesn't have a hearing. I yield back.
Question occurs on the amendment offered.
Chairman.
What first gentleman from New York seek recognition?
Strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I rise in support of the amendment offered by Mr. Cicilline for the gentlelady from Texas, Ms. Jackson Lee. The bill as offered, the bill in front of us, would reduce funding under certain programs to a state by 100% if the state did not collect and release the name of each defendant participating in a pretrial release program, and whether that defendant failed to make an appearance when he should have, and information relating to the previous arrest record of each defendant participating in the pretrial release program, and the amount of money allocated for the pretrial release program. The amendment would leave in place the amount of money allocated for the pretrial services program, but it would make two essential changes. One, it would say we don't want to release personally identifying information, but we do want to release information that's useful in the evaluation of the program. So it says, instead of releasing the names of defendants participating in pretrial release programs and whether they showed up or not, it says we should release the percentage of defendants who are released on their own recognizance, not their names, but the percentages of such people who participated in a pretrial release program without bail, the percentage of such defendants who were released on bail, the percentage of such defendants who were released on bail who showed up for their hearings, and the percentage of people who were released without bail who showed up for their hearings. This at least gives us useful information, and the percentage of such defendants who completed the pretrial period without being arrested for any subsequent unrelated offense. This gives us useful information for evaluating the pretrial release program. Is it effective or is it not effective? Should we change it? Should we not change it? Evaluating the effectiveness of the bail system. Does it work? Does it not work? It gives us useful information without invading the privacy and putting out the personal names, which the public, which is unnecessary. So it improves the bill. If the purpose of the bill is to give information so we can see the effectiveness of what we're doing, this certainly improves the bill. I don't know of any other purpose for the bill. Now, the chairman says that this would somehow eliminate the nexus, I think I'm restating it, would eliminate the nexus to the funding. No, the funding referenced in the bill, which is not changed by the amendment, is any grant program operated by the Department of Justice which uses funds received under such program for a pretrial services program. We're still dealing with the same program, with the same funds rather, but we're requiring information useful to the evaluation of the effectiveness of those funds, of that program. It's direct nexus because it tells us, is the program working, is it not working, perhaps could it be improved? So I really don't understand the objection to the amendment. I don't understand how you can say it removes the nexus to the funding, and I don't understand why you wouldn't want this information, which is actually useful information, as opposed to the version of the bill now, which has a little useful information relating to the previous arrest record of each defendant, whether they failed to make an appearance. That's useful information, but the personal names are not useful information and are invasion of privacy. So we're being a little more comprehensive here. We're taking out the invasion of privacy, but we're giving more information as to whether the program is working, how it might be improved, et cetera. And we're using exactly the same financial incentives to the state. We're not changing that in the bill at all. So it's exactly the same nexus, better information, and I support the amendment. And without the amendment, you've got a bill that's much less effective in giving us useful information, number one, and is invasive of personal privacy rights for no particular reason and no particular gain. So therefore, I support the amendment. And I have to say that without the amendment and without removing the personal names, we would have to oppose, I would have to oppose the bill. I yield back.
Question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the noes have it. The amendment is not.
Request a recorded vote, Mr.
Recorded
Chairman.
vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. King? Mr. King votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Ms. Handel? Ms. Handel votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Ms. Demings?
The gentleman from Idaho.
Mr. Labrador votes no.
Gentleman from Tennessee.
Mr. Cohen votes aye.
Has every member voted who wishes to vote?
Mr. Chairman, how am I recorded?
The gentlewoman is recorded as a no.
Thank you. Am I recorded as a no?
Oh, it's an aye. I apologize.
Oh, I better check.
You
Mr.
had me there
Chairman.
for
How
a
am I
minute, Mr.
recorded?
Chairman.
Better clarify that. The clerk will report how the gentlewoman is recorded. The gentleman
Aye.
from California, Illinois.
Mr. Schneider votes yes.
And am I corrected that the gentlewoman is of an aye on the amendment? The clerk will report.
Mr. Chairman, 9 members voted aye, 11 members voted no.
And the amendment is not agreed to. Are there further amendments to the amendment in the nature of substitute?
Mr. Chairman,
For purpose, the gentleman from Rhode Island seek recognition.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2152 offered by Mr. Cicilline of Rhode Island. Page 2, beginning on line 4, strike.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment would strike on page 2, line 4, the words "the previous arrest record" and replace it with "any prior convictions." My amendment would modify what state and local governments are required to report regarding the criminal history of defendants participating in pretrial service programs. Under the current language of H.R. 2152, governments must submit defendants' previous arrest records. My amendment would instead require state and local governments to submit information relating to any previous criminal convictions of defendants, because this is a more realistic metric of whether a defendant will succeed during pretrial release and much more likely to be the information already collected by pretrial services and provided to the court. In making this determination, a judge must consider the nature and seriousness of danger to others in the community, as well as evidence of the defendant's character. When examining the history and character of a person, the court will certainly consider the person's criminal history. However, arrest records are disproportionately higher among people of color and low-income communities. Such individuals are subject to a lopsided arrest rate as a result of racial and class disparities at every stage of the criminal justice system, and this is confirmed by research by the Center for American Progress and the Justice Policy Center, as well as many other organizations. As a result, an arrest history is not helpful for judges when determining character in a detention hearing, nor is it necessarily dispositive of defendant's behavior. In contrast, a criminal conviction is more helpful to judges when considering the person's character and dangers to the community. A criminal conviction better reflects the defendant's actual actions, which the defendant has been found without a reasonable doubt to have committed. It may be reasonable to require pretrial service programs to provide data related to the outcomes of their work. However, the information reported should reflect the realities of the criminal justice system and prioritize the goals of pretrial release, including public safety and ensuring court appearances, as well as honoring our constitutional standards. So I urge my colleagues to support this amendment, which I think is common sense, will ensure that the best and most accurate information is included, and will at the same time comport with accepted constitutional standards. And with that, I yield back.
Would the gentleman yield?
Happy to yield.
I think the gentleman's amendment is well-founded, and I support it, and I urge my colleagues to join me in accepting the amendment. The question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it. The amendment is agreed to. Are there further amendments to the amendment in the nature of substitute?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2152 offered by Ms. Jai Paul of Washington. Add at the end of the bill the following. Section 3 GAO report on bail bondsman practices. Report required, not later than 1 year following enactment.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you so much, Mr. Chairman. I did want to begin by adding my agreement with many of my colleagues who have spoken out about the need to have hearings on gun safety laws in this committee. I'm very proud of my home state of Washington that just yesterday became the latest state to pass, and the governor signed yesterday, a ban on bump stocks. And we also just had a Senate committee pass a bill that would enhance background checks on rifle purchases and raise the legal age to buy rifles to 21. And Mr. Chairman, I just believe that Republicans and Democrats across the country are looking for ways to make our kids safe, to have them be able to go to school without worrying about being shot, to have them be able to go to school fully focused on learning. And these young people are incredible. They're courageous, they're brave, they can't vote, but they expect us to do what is right for them to be able to survive. So I really hope, Mr. Chairman, that we will have some hearings on responsible gun safety legislation so that we can actually address some of the critical issues that are in front of us. I did want to say that there is a connection between this bill and the NRA in that this bill in states across the country has been promoted by a group called ALEC, and that is the American Legislative Exchange Council, funded by the NRA, by the Koch brothers, has moved a number of bills around stand your ground in states across the country. And my concern, Mr. Chairman, is that I think that this has been a way to undermine the pretrial programs across the country and to actually try to bring in more money for a private bail bondsman industry. And so my amendment simply says if we're going to get information on the pretrial programs, let's also ask the GAO to do a report to hold bail bondsmen to the level of transparency that this bill demands of pretrial services programs. Mr. Chairman, there are currently no surveys to support any reported use of evidence-based practices by bail bondsmen. In stark contrast, nearly all the pretrial service programs report using objective risk criteria to evaluate whether someone can be safely released into the community under supervision. And while I don't believe that it's necessary to subject pretrial release programs to further reporting and scrutiny, and I completely agree with Mr. Nadler's previous amendment to actually completely eliminate the bail money program, it only follows logically that if we're going to require this information of the pretrial services programs, then we should also subject bail bondsmen who will benefit from this bill to the same level of scrutiny and transparency. I hope that this information will lead us down the path to finally eradicate money bail, but if we find information that is to the contrary, then we would be interested in that information as well. Currently, only the United States and the Philippines permit this unjust practice of writing bonds for a profit to exist. Most countries, including England, Canada, Australia, and others, have eliminated this model as unsafe, and 4 states Illinois, Kentucky, Oregon, and Wisconsin have actually abolished the practice. Instead of cracking down on pretrial release for the benefit and profit of bail bondsmen, we should be looking at ways to strengthen and expand pretrial release at a minimum. Taxpayers spend about $38 billion each day on pretrial detention, and yet about 60% of people in jail are there not because they have been convicted of a crime, but because they simply can't afford bail. Pretrial release programs cost just a fraction of continued incarceration. On average, $7 a day compared to over $200 a day for a jail bed. I'm deeply troubled by the fact that we continue to jail people for low-level offenses, things like sleeping under the highway or driving without a license, simply because they can't make bail. A May 2017 report by the Federal Reserve found that 44% of Americans would not be able to come up with $400 to cover emergency expenses. Imagine then how difficult it is for people who have lower incomes to come up with anywhere from $500 to $2,500 for bail. Locally, the District of Columbia eliminated its reliance on money bail, and consequently, 85% of defendants are released before trial. Of this number, more than 90% return to court and stay arrest-free while their cases are pending. This has huge benefits for our communities and our economy, but most importantly for people who would otherwise be incarcerated and their families. People should not lose their jobs or their homes because they're incarcerated while they await a fair trial. Families should not have to choose between putting bail for a loved one or putting food on the table or paying rent. So this amendment is really just to say, let's get the information about the bail bondsman industry at the same time. I know in my home state of Washington, we've tried a number of times to get information, but because they're private, for-profit, it's a private for-profit industry, we have not been able to get the kind of information that we need. A GAO report would allow us to get information from both the pretrial services as well as the bail bondsman industry and really evaluate how well this system is working for us. I hope that my colleagues will approve this amendment, and I ask for your support, Mr. Chairman.
Would the gentlewoman yield? And without objection, the gentlewoman is recognized for an additional minute if she would yield to me.
Of course.
I think your amendment is well-intentioned. It's a lot to digest here. We just received it. A couple of things I would suggest. One, if you would be willing to withdraw the amendment, we will work with you in good faith to incorporate as much of this as we can in the bill as we move to the floor. But in addition to that, there's no need to have legislation to request a GAO report. So above and beyond what we do with the legislation, if the gentlewoman would again withdraw the amendment, I will be happy to work with her on requesting a GAO report. We can do that without legislation.
I'd be happy to do that, Mr. Chairman. I'll withdraw the amendment, hope that we can incorporate some pieces of this as well as write a letter with you requesting a GAO report.
I'm sure we can do that. Without objection, the amendment is withdrawn. Are there further amendments to H.R. 2152, the amendment in nature of substitute?
I'm on a streak of good luck, Mr. Chairman, so I have another amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2152, offered by Ms. Jayapal of Washington. Page 2, insert after line 24.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
Thank you, Mr. Chairman. This amendment would just exempt states and local governments that already provide the release information that's required under state sunshine laws. So in states like Florida, for example, pretrial service programs have long tracked data on participants, and the information is available to the public under Florida sunshine laws. And all of this was true actually prior to a Florida 2008 passage of a law similar to the one that we're considering today. So under that law, Florida programs were required to produce new and, in my opinion, redundant reports rather than focusing on the true mission of helping the courts and supervising defendants. And following passage of the law, the Florida legislature found, and this is a quote, that some of the reporting requirements add limited value or are ambiguous, close quote. So who does find these reports useful? Bail bondsmen seeking to use the data to undermine pretrial services so they can increase their profits. And we need to be clear about the intent of this bill. And under the guise of increasing transparency, I believe that it's doing something else that seeks to undermine these pretrial programs. All my amendment does, Mr. Chairman, is says that if states are already providing this information and it's available under the sunshine laws, then let's exempt those states from having to do more work and duplicate, frankly, in many instances, the work that they're already doing. I hope that you might accept this amendment, Mr. Chairman, and I ask for support. I yield back.
Chair thanks the gentlewoman and recognizes himself to oppose the amendment reluctantly, but I frankly think the language in the bill is more practical. This amendment would necessitate the people in the Department of Justice having to ascertain each and every one of these laws and then jurisdiction by jurisdiction, state by state, contact them to request the information, whereas in point of fact, if you have a sunshine law in a particular state, you're already providing the information. It's not a significant additional burden to simply send it on to the federal government as well. So for that reason, I don't think this is a practical amendment and I would have to oppose it. Again, if the gentleman wants to withdraw, we're happy to work with her, but I think that the bill as drafted is more practical.
Thank you. I'm going to go ahead and just keep it in, but I
Okay.
appreciate your comments.
The question occurs on the amendment offered by the gentlewoman from Washington. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. The amendment is not agreed to. Are there further amendments to H.R. 2152, the amendment in the nature of substitute? The question is on the amendment in the nature of a substitute as amended. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment is agreed to. We're going to go to final passage. Yeah. The ayes have it, and the amendment in the nature of substitute is agreed to. The question occurs on reporting the bill, a reporting quorum being present. The question is on the motion to report the bill, H.R. 2152, as amended favorably to the House. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
Ayes have it. A recorded vote has been requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Buck? Mr. Buck votes yes. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana? Mr. Johnson votes yes. Mr. Biggs? Mr. Biggs votes yes. Mr. Rutherford? Ms. Handel? Ms. Handel votes yes. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Ms. Demings? Mr. Schneider votes no. Ms. Demings? Ms. Demings votes no.
As the gentleman from Idaho.
Mr. Labrador votes yes.
Gentleman from California.
Mr. Issa votes yes.
Has every member voted who wishes to vote?
No.
Gentleman from
Yes.
Texas.
Yes.
All right, the clerk will report.
Mr. Chairman, 14 members voted aye, 10 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. I thank all the members for attending, and the markup is adjourned.